please. I pledge allegiance to the flag of the United States, to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Senate Judiciary is now in session. We're going to start with SB 460. The Honorable Denise Ricciardi. Great to see you, Senator. Take it away.
Nice to see you too. Good afternoon, Mr. Chair and members of the committee. I am Senator Denise Ricciardi, and I represent the beautiful people of District 9. I'm here to speak to you about Senate Bill 460 FN. This was at the request of the Department of Safety. Senate Bill 460 strengthens child safety without imposing broad or punitive restrictions. The bill applies only to a very specific and high-risk subset of offenders, individuals required to register because of sexual offense committed against a child under the age of 13. The bill protects children in the places where they are most at risk. It prohibits these offenders from knowingly appearing within 1,000 feet of schools, playgrounds, child care centers, and other child-focused locations under circumstances that would warrant alarm. The bill would give law enforcement a preventative tool they currently lack. Too often, officers encounter individuals in sensitive locations, but cannot intervene until a child is approached or harmed. It is a measured step that helps prevent harm before it happens. The bill strikes the right balance between public safety and civil liberties. It does not impose residency bans, employment restrictions, or lifetime movement limits. It simply creates a reasonable buffer around places where children gather, triggered only by suspicious behavior. Thank you very much, and I'm sure the department can answer any questions you may have.
Thank you very much, Senator. We're all set.
Okay, thank you. I have to go to transportation.
I know
Sorry.
you do. Have fun. Jackie Cowell from the Early Learning, New Hampshire.
Good afternoon, Chairman
Afternoon.
Gannon and Senator Altschuler. My name is Jackie Cowell. I'm the Executive Director of Early Learning New Hampshire. We're a statewide nonprofit focused on supporting childcare programs and the families they serve, and we are in support of SB 460. In fact, I wanted to let you know this particular idea for the bill originated from the field. We host twice monthly Zoom calls with over 100 people on it, talking about upcoming priorities, and this came up as a worry. That their folks had been talking to their local police departments about some concerns they had, but there was nothing that the police departments could really do. And so the folks from the field actually went to the Department of Safety, met with Associate Commissioner Edwards and Commissioner Quinn, and this is how this originated, and we very much support it. And we think, as Senator Ricciardi said, it's a reasonable, common sense bill, and I thank you both for co-sponsoring it.
I did. I'll ask you a question though anyways.
Okay.
And I'm all in sympathy. There's a place called Connaught in Ireland. That's where I would send these
Oh,
people.
really?
And they would be close to no young children. But we don't have that option.
Okay.
So how far, like if you have the map of Manchester,
Yeah.
and I'm sure Commissioner
this
Edwards
is
would
good.
know
Right,
all
okay,
these
good.
answers, and he's just walked in, so that might be good. Am I giving these people, is 1,000 feet going to make it impossible for them to maneuver around the city?
I see.
Any childcare facility, any church, any school.
All right. Okay.
I got to give them enough room so that they can
Yeah.
function. I like your 1,000 feet idea. I co-sponsor.
But how would that work?
are there?
Yeah.
Is that enough? Are we giving them enough room that they can avoid? I don't know how many child care centers
Yeah,
there are, say,
yeah.
in Manchester. And
There
if it
are.
would that make it impossible for a person who in this position to
Thank you.
function?
And I think part of it was loitering and prowling. It was sort of hanging around as opposed to walking around.
Okay.
Is my understanding of it.
That's a
Again,
good way to look
with
at it.
no other known purpose for being there.
Okay, sounds great.
Great.
Okay, thank you for your testimony.
Thank you.
Molly Tremblay. Good afternoon, Ms. Tremblay. How you doing?
Good, thank you.
Good.
My name is Molly Tremblay. I am a center director in Claremont, New Hampshire. This is my first time testifying, so bear with me. So, for the past few years, we, as a center, have been having these concerns of sex offenders who will literally stand on our sidewalks, stand outside, stare in our windows, drive by, take pictures, and going to the police department, they're telling us there's nothing they can do. There's nothing that prevents them from doing that. There's nothing from them standing on our corner and just watching our children. I have a lot of children in sensitive situations, a lot of foster care, a lot of protective care, and they have been through so much already, and it's just not fair to them to keep having this happen. It's not fair to my staff to have to literally go through the sex offender registry and study it to make sure that we're looking out for these people. And it's just not fair to the children. It's not a safe situation at all. And when we are on edge as educators, the children feel it as well. It's not just us, it's the children. It passes on to the children, and that is the most important thing to us and to us as a childcare field, that these children are number one. So yeah, thank you for considering this bill, and yeah.
Thank you very much. Do we have any questions? Senator Alshuler.
Thank you, Mr. Chair. Thank you, Ms. Tremblay. You did a great job. And thank you for your work in childcare. We really appreciate that. Just want to clarify, you mentioned that you have children in sensitive situations. So we know that that could mean parents who have an acrimonious relationship or are separated, or a child is in foster care. Would this impede parental access?
I'm not sure. I have had a parent that has been on the registry before, and they were just like, it has to be a condition of their parole that they're not allowed in the center. But it also depends on a certain case scenario of what DCYF says.
Thank you. And I think for the chair, 1,000 feet is just under 2/10 of a mile of navigable space. So,
Gotcha.
yeah, thank you so much.
Commissioner, can I grab you and lay this side up? You're always ready. No, you're always ready. It's just the prime minister advocated to you and any questions. So my two questions. One is, you said no here, so is that loitering? This is that we're trying to loiter right there in the little analysis. And then when you read these descriptions, the actual stuff, there's knowingly appears. So if somebody's just walking through within 1,000 feet, are they okay? Is it when they loiter and hang around the temple?
Yes, sir. For the record, my name is Eddie Evers, Assistant Commissioner for the Department of Safety. To my left is Captain Vic Muzzy, New Hampshire State Police. To answer your question, yes, sir. Loitering or prowling with the purpose that creates a public alarm.
So do we need to add a,
Warrants alarm, I'm sorry.
do I need to add knowingly appears? If I'm looking at the graph, RSA 51B, and if I see knowingly appears, I can see the word loiter.
But I think that's within the statute. Yeah.
It says knowingly appears in the new.
It does go on to say
In the new.
under circumstances that warrant alarm.
Yeah.
So Senator, I don't know if it matters, but continuing on in the same phraseology, it does sort of allude to appearing in those places under circumstances that warrant alarm. So it does sort of bring it to that extra level versus simply appearing,
Right.
if that makes a difference.
Is that 1,000 feet? Is the 1,000 feet giving this registered tier 2 offender? Is it giving him enough room, say in Manchester, so he can function? Is 2/10 of a mile gonna block it so he can't go anywhere? Are there, because I'm assuming there's daycares all over the place, churches, schools. Are there too many of these things in a city that he can still get around and avoid? And you're saying it's loitering too?
Right, absolutely. He has to be there, and I think what the captain just pointed out, that warrants alarm. So a tier 1 or 2 sex offender simply walking past or walking in an area doesn't trigger that. They linger there for a purpose. I mean, that warrants their behavior is what would trigger that.
You got me in the ballpark now. Thank you very much. Any other questions? Cinderella? You looked like you might have something. We are great. Thank you for coming up. And even though I pulled you out of the street here. Speak.
No problem.
Thank
My
you.
pleasure. Thank you.
Anyone else wish to testify on SB 460? Seeing none, that'll end the hearing. Yep. Senator Birdsell, we're all ready when you are. We're going to start SB 625. The Honorable Senator Birdsell is going to introduce the legislation for us. Thank you, Senator.
Yep, sorry. Thank you, committee. Thank you, Mr. Chair, for hearing Senate Bill 625. This stems from, for the record, my name is Regina Birdsell, State Senator for District 19, which encompasses the towns of Derry, Hampstead, and Windham. And this particular bill comes as a number of years ago, if you remember, I had put in a bill regarding I presented legislation to make sure that the deceased body or the deceased body does not go back to the if it was a spouse being shot or the ex-spouse to make sure that the body does not go back to the spouse if the its spouse shot their spouse. Sorry, I'm just getting confused. So that didn't go through because there were some concerns from the funeral directors, if you recall, that they said it was actually covered. So I just want to continue bringing this case to light. And I did talk with the Commissioner of Safety as well as the Attorney General's office. And in reviewing the reports from both the state police and the AG's office, there were some major concerns that happened during the investigation. And the Department of Safety also agrees that the investigation was somewhat flawed. So what this bill does, and I will say that there are, I think, 11 states that have some format of this bill. But what it does is it allows a parent, the title of the bill is, this bill permits family members of intentional homicide victims to seek an evidentiary hearing in cases where the Department of Justice does not file charges in the case or does not seek a retrial following a hung jury. So what this does is a parent, spouse, or child of the deceased may request a written explanation as to why the charges were not filed or refiled from the DOJ, and an explanation from the department shall be provided to the requesting party. In the following cases where the state medical examiner has ruled that the deceased person's manner of death was a homicide. Any case where the Department of Justice opened an investigation for intentional homicide but has declared that the case is closed without filing any charges. And in any case where a defendant has been charged and tried on a charge of capital murder, first-degree murder, or second-degree murder, and a mistrial was declared as to the charge as a result of the jury's being unable to reach a unanimous decision. It also says that the Department of Justice shall not be required to provide the written explanation identified in this paragraph if the department considers an investigation still open. If requesting party believes there is probable cause to charge a person of interest having committed a violation or that a retrial should be sought, the party may petition the Superior Court in the jurisdiction where the homicide occurred for review of the Department of Justice's written explanation not to seek charges. And this is kind of the crux of where I wanted to go, because there was a absolutely flawed investigation, as we know, and the family really had no recourse, and they spent years trying to get answers. They couldn't get answers. We finally, and obviously no charges were filed against the spouse, and she is long gone. And so the family was left with really no information for years, 3 or 4 years, as to what happened. And there are still some questions in their mind on what happened. So this would give the family a chance to at least, if the Department of Justice is taking so long, or the Department of Safety are taking so long to make a determination on the investigation, then this gives the family some way to get some answers as to what the status is. So if the court, it also says if the court determines that a written explanation is insufficient for it to make a determination, the court may require the department to provide their investigative report so the courts can review it. The court may also hold a hearing and examine any witnesses that the court determines to be necessary and appropriate. And if the court determines that probable cause does not exist, the court shall inform the requesting party in writing that charges against the identified person should not be filed for lack of. So basically, it's just allowing the families to get some closure, some way to get some closure on an investigation that has been taking so long, or that no charges have been filed, but yet there's concern about the type of investigation. And as I said, there are a number of states, Alabama, Arizona, Georgia, North Carolina, Ohio, Pennsylvania. Many of these have some sort of citizen availability to go to the courts to get some remedy. So with that, and I do have a number, I have the family here who's going to be testifying.
Thank you. Senator Oshler.
Thank you, Mr. Chair. Thank you, Senator, for bringing this forward. I'm wondering if you could just walk me through a couple of the pieces here. I guess I'm not understanding how the family gets closure when the Department of Justice is not required to provide a written explanation. You know, I'm in one part of the bill, it says that you have the opportunity to ask for some explanation, but then the Department of Justice is just like, no, we don't have to. So
Well, I think in the intent of this bill is to have the family go to the courts and say, you know, hey, there's something going wrong with this investigation. Then the court can do an evidentiary, the court can do an evidentiary hearing. If they feel that if they look at the evidence and they see that there's nothing that can be done, they will actually tell the family in writing. So there is some closure there. If the courts feel that there is something untoward or there's no closure there, they can have an evidentiary hearing and look at the evidence that the parties have and review it, and then they can go to the family and say, yes, there is some concern, or no,
we're confident that the investigation is completed. Any follow-up?
Follow-up?
So just walk me through where could the family not just request, but is there a requirement that the evidentiary hearing be held? Or is that still up to the court's discretion?
My understanding is that it's really up to the court's discretion because again, they're going to be looking at the family can ask for it. The courts will take a look at what investigation has been done. They can request the information from the DOJ, the state police, whoever's doing the investigation, and they can review it themselves. And if they feel that the investigation is completed and they're happy with it, then they will give the family in writing their explanation.
Okay, last follow-up.
Yes.
So the courts will give this to the families in writing. But if the court decides or determines that there's no probable cause to go forward any further, they're not required to explain why.
That if the court determines that probable cause does not exist, the court shall inform the requesting party in writing that charges against the identified person of interest should not be filed for lack of probable cause.
And they're not required to give an explanation as to how they arrived at, we don't find probable cause because it's just period. We do not
Right,
find
because-
probable cause.
Because the family is knowing that the courts are looking at the evidence and there's a second or third eye looking at this to verify.
Thank you for walking me through that. Really appreciate it. Thank you.
Thank you, Senator.
All right, thank you.
Have a good day. The two Perkinses, Lynn and Karen. Good afternoon to you both.
We good? You got it? Thank you very much. Len and Karen Perkins here speaking on behalf of Senate Bill in support of Senate Bill 625. And we thank you for being here and entertaining us today. We are in support of Senate Bill 625 pursuant to the due process under the U.S. Bill of Rights, Article 14, and the New Hampshire Bill of Rights, Sections 14 through 17, relative to the murder of Michael Carney. That is the case that we have, that has catapulted us here in front of you today. Testimony will touch lightly on details of a murder for context aspects only, and focuses mainly on the details of the investigation afterwards. Names are spoken, but they are already known to the public in relationship to this, and have those names have already made public comment on this. As we proceed, I would just ask you, I was here last Thursday, and I would ask you to reflect on a testimony you may have heard on Senate Bill 621 and how it contrasts to what the information we're going to share with you now. Go ahead.
We love you.
You're the best mom.
Thanks for breakfast. I'll try to get over to see you today.
Don't risk it if the roads are bad.
Don't forget I left pulled pork for you in the refrigerator.
Senators, in the findings of the Attorney General's report, they establish the primary elements for not charging somebody as being estranged. And I ask you, those are the text messages that went on between Michael Carney, my brother-in-law, and his wife, all until the morning of his death. And I ask you this question, when you hear those text messages, does it say to you, oh yeah, this couple is estranged? In my viewpoint, that is not the case. Michael Carney's wife, Nicole, called 911 the evening that Michael Carney was shot. And she proclaims that the couple is estranged. In her police interview after killing her husband, she admits they are not separated. The press release from the Attorney General in July 2017 with Gordon McDonald, Jeffrey Strelzin, and Colonel Wagner all stand that the estranged is the primary element to justify the homicide. And that was under the stand your ground rule. Michael Carney lost constitutional due process because certain law enforcement officials, including in the New Hampshire Department of Justice, chose a favored individual, Keene Police Chief Brian Costa, over right and wrong. What the 91A information shows is that the investigation and collection of evidence was never fully completed. Infringement of the investigation occurs when a Lieutenant DeRusso from Troop C orders stoppage of elements to the investigation. The collection of the 91A information becomes central to why Senate Bill 625 is necessary. The sad part is that Michael Carney's wife, admitted shooting her husband once in the back and in the back of the head. She ends up being the beneficiary of a poor decision by law enforcement, and hence she's not charged, and it's to protect Costa's image. The evidence is never brought to a grand jury for indictment, but just as an arbitrary decision by law enforcement of guilt or innocence. This has been our protest all along. We have asked the AG's department to tell us if you're going to prosecute, and if not, why not? It's a simple question, and we cannot get that answer. You're going to find out why in just a minute here. Reports that show multiple officers protest the orders from DeRusso, with complaints reaching Colonel Wagner of the state police, who then purportedly escorts Lieutenant DeRusso into safe retirement. Records outside of the 91A information show that those officers are retaliated against by upper command. Senators, in your packet, you have the document that I am referring to. Senator Gannon, as chair, I will ask for your discretion as to the exposure of that document, and it is in the back of your packet, Senator Archuleta. When In-Depth New Hampshire ran an article last January, two things happened. The first was Attorney Garrity from the Department of Justice stated that there was no cover-up here, and any information that would be valuable to this would be looked at. But when Karen Perkins communicated with Assistant Attorney General Strelzin with her concerns about the investigation in 2019, Attorney General Strelzin converted her inquiries into a 91A request when she should have been treated as a witness. In addition, my wife was asked questions the day after her brother's murder by state police who came to our home in Derry. And twice she tried to follow up with information with that officer and never got a call back. When the findings were released, the report twists comments my wife made on that day and on February 10th, 2017. In the statements that Nicole Carney made were twisted and associated with my wife's comments in the official AG report. When the AG Strelzin states that he was making my wife's inquiries as a 91A, that allows the Attorney General's office to start to stall the information to get to us. Eventually, they turn around after some time and decide to reopen the case again, which increases the stall. The contradiction to Attorney Garrity's statement, we have spent several years, several $1,000s in legal costs to finally receive the revealing 91A information so our voices can be heard. Again, we address Senator, we support Senate Bill 625, and I think you can see why. In 2024, we sent our findings to AG Formella twice. And during that time, once in April by certified mail, the second time in July. Assistant Attorney General Agati responded. He set up an appointment with us on August 13th, 2024. And just so you understand the timeline, 2024 is we weren't able to get all of our 91A information until late in 2023 when Jeffrey Strelzin assembles that 91A in 2019. So we're approaching 4.5 years to get our 91A information after they've said the investigation is closed. We have the discussion with Assistant Attorney General Agati. It was very gratifying. He told us that we deserve the dignity of understanding why there were no charges in this case. He also was critical of Mr. Strelzin for not providing us that information before telling us that there was nothing to see here. We couldn't refute it. We had a follow-up meeting scheduled for September 3rd, and a half an hour after our scheduled time, Attorney Agati sent us an email informing us that he was tied up preparing for another case, and he offered September 10th as an alternative date. We were working the polls in the town of Derry for the primaries, and so we offered September 9th. You do have a copy of these emails, by the way. We didn't hear anything back from him, so the next week we proposed another alternative date to follow up with him, and we heard nothing. And when we talk about the hearing for 621 last week, the emphasis of not needing an intermediary between the families of cold cases and the cold case team itself, they're talking about how there's open communication. But I think you can see here, there's starving for open communication. We provide 2 other alternatives to Mr. Agati, and we never get acknowledgement. We eventually sent an email to Mr. Agati and to Attorney General Fromella, asking for an update, and we recapped everything that went on in that time from July up until that point, and we heard nothing. Just so you know, we eventually take our findings and we give them to all of our state reps in Derry, and there's not a one of them that does not sign a petition that goes to the governor, Governor Sununu, which we handed to him. And we were told by his counsel that Mr. Fromella would be contacting us. That was the second time that promise was made, and that was the second time that promise was broken. The Department of Justice may insist on their first findings, which I think we have disproven, but Nicola Carney admits that she and her husband were separated. Michael Carney's death occurs in a house his wife purchased without his knowledge in Stoddard, when their common law domicile was in Sullivan, making details of this murder very murky. The problem is we are never approached by state police. My wife is never approached by state police to finalize that investigation. When my wife spoke with AG Strelzin in 2019, she informed him that there were officers that disagreed with the AG findings in the murder of Michael Carney. Mr. Strelzin strongly disagreed with that. You have that information in your packet, along with your 91A information that shows contradictory information to that. The second thing that happened when In-Depth New Hampshire posted the story on last year relative to Michael Carney's death, we started getting phone calls. Some of them were late night phone calls. One was from a retired police officer calling us from his basement because he didn't want his wife to know that he was getting involved. We had witnesses that called us. We had that were in and around the scene and at 106 Moose Brook Drive, as well as other police officers, retired, who started to come forward. The details that were part of the 91A information were being revealed, or that were not part of the 91 information, and started to make sense to the cut and pasted documents we had received from the Attorney General's office over a lengthy period of time. In 2020, the authorities, in what they state is a reinvestigation, interviewed Sergeant Scahan, the lead investigator in the Carney murder, as it tied to the Costa suicide death. Understands Chief Costa, and I feel very bad for him, because as much as we know about our own circumstances, we understand the circumstances that have followed his children. His son was shot last year trying to get answers about the death of his father. In the interview, Sergeant Scahan is interviewed by a captain from the state police, and I've retracted his name because his name is not known publicly, and Trooper Elphick, who is known publicly. Sergeant Scahan is repeatedly asked hypothetical questions to entice him into saying the investigation was fine which he finally reluctantly does. In May 2022, in some 91A information, understand this is 2022, and the request for information that Mr. Strelzin created started in 2019. My wife receives a copy of an email from Sergeant Scahan expressing concerns about the Kearney investigation, which he had asked for permission to reinvestigate in February of 2019 from a lieutenant other than Lieutenant DeRusso. Coincidentally, my wife contacts Scahan in August of 2019, and Sergeant Scahan drives to our home to review her concerns, then abruptly retires in 2019, in November. The email we reference was on the eve of his retirement. You also have that in your packages. When we finally get the information from the 91A process in 2023, in it are the multiple officers that express concerns about the investigation contrary to Mr. Strelzin's position, including Sergeant Scahan. Just 6 weeks ago, we had a retired state police officer visit our home. We were informed that Trooper Elphick squashed the evidence because Michael Kearney's family wanted a reinvestigation. That is purported to have happened in the barracks in Troop C. We also learned from a former state police sergeant that when Assistant AG Strelzin arrives on the murder scene, he is informed that the scene looked staged and something wasn't right. Purportedly, Strelzin replies, just because someone commits murder doesn't mean we can prove it. But Nicole Kearney, immediately after her husband is shot, stands around her husband's body and starts to delete all the text messages and contact information between herself and Chief Brian Costa. That's evidence tampering, and a whole lot worse than what we have heard about in the Marconi case. We support Senate Bill 625 with a couple of suggested amendments. We support this bill because no family should have to go what we have gone through and what we've just explained to you. We support it because it helps ensure the constitutional right of due process, especially when laws such as violations of United States Code 18, Section 241, conspiracy to deprive rights under the color of law occur. Our suggested amendments are the bill should not have a non-retroactive stipulation. There is no statute of limitations for murder, so this should not be excluded. Section 1A should also be allowed beside the parent, spouse, or child, should also allow the siblings or next of kin to be able to file these charges or to appeal to the court. As Senator Birdsell expressed in her filing of this bill 2 years ago relative to domestic homicide, when one spouse kills another, the deceased spouse is not to go back to the assailant. That we discover in hearing was already a law, and the AG's office and coroner's office violated that law and returned Michael Kearney's remains back to his assailant for her to cremate those remains. The coroner's office had contacted my wife, so they knew of her existence, but instead they diverted and sent his remains back to his assailant, where he was again cremated. If the law, which I think is 290, you remember that one? 290, it was the bill that came out with Senator Birdsell. If the law says that the next of kin is to get the remains, why can't the next of kin file the amendment or a petition to the court to evaluate the information, the evidence, and make a determination? I think that's one amendment that is appropriate. To wrap up, and I appreciate your patience. In the AG report, it says Nicole Kearney did not use excessive force. Contrary to this, Nicole Kearney stated she heard Michael Kearney yell out, and after the first shot, so she shot him again. Now you tell me, is that reasonable or is it excessive? Folks, we rest on that. I appreciate your patience, and we try to consolidate that down.
Sorry for your loss. Thank you for your
Thank you.
testimony today.
Very sorry for your loss.
Thank you. It's, Michael Kearney had 2 teenage boys when this happened. They're in their 20s now. Officially, what I notice in this bill is that, that seems to be a requirement that there's a written statement provided to the family when there is a murder. You know, my wife, the state police came to divulge or to hand the report of the findings of this. And they called our home that morning. My wife answered the phone and they said, we need to send an officer by your home. Can you be there? So I waited. I didn't go to work. The officer showed up, handed the AG report to my wife and said, you've got 45 minutes to read this before it goes out to the press. That was the compassion that we received from this. And I think it's telling because what you're seeing in the AG is that they don't want you to see what's going on here. So they hand you this document. They don't even explain it. And it all rests on the element of their being estranged. There's mortgage fraud in here and there's tampering with evidence. I think it shows how gross this is. We'll take any questions if you folks like.
We're all set. Thank you very much.
Thank you very much for your patience.
Ben, we're going to go 3 minutes. Everyone else. That's the way. Lauren Warner. So you'll time it for me, Ben? You'll time it. Good afternoon.
Good afternoon, members of the committee. My name is Lauren Warner, and I serve as the Deputy General Counsel for the Judicial Branch. Just to start off, to note, the branch does not take a position on this bill, but I'm here happy to take any questions you might have related to the fiscal note or as to the impact that this bill would have on the judicial branch. But I wanted to note just a few areas of impact for the committee. First, in noting the bill states that a family may petition, or anyone who may be a petitioner under this bill would petition the court where the homicide occurred. In that case, that would recuse that judge from then potentially hearing any criminal case that may come forward if, say, if the judicial branch recommended a conviction charges to be filed and the Department of Justice then subsequently filed charges. Any judge who would review these petitions and review the investigation, potentially conduct an evidentiary hearing, would be disqualified from then overseeing that case. So in those matters, we would, as noted in the fiscal note, we recommended a hiring of an additional judge to be able to review these matters. As we have 22 Superior Court judges that sit, we would need an additional judge to review such petitions. Also noting the evidentiary hearings that would be allowed. Likely in any case, if a petition was made to the court and the court would be reviewing the Department of Justice's file in order to adequately review such a petition. In most every case, I would assume there would be an evidentiary hearing to determine the credibility of the witnesses. In those matters, there were just a couple of questions we have. In these cases, the witnesses that would come forward, would they be required to potentially have an attorney present to represent them? Would the state be examining the witness and the suspect cross-examining the witness? There are some kind of open-ended questions left in this bill as to those evidentiary hearings. I would also note in the bill, any evidentiary hearing, the suspect is then put on notice and is able to cross-examine the witnesses. In this case, there are times where a suspect may not be aware they are a suspect or certainly does not have access to the state's investigatory file on them. This would then allow that suspect to be put on notice and essentially to see the state's case against them before a conviction was ever brought and a trial is held. Then as well as just noting the burden of proof in the bill is probable cause. The judge would review the file and determine if there's probable cause for charges to be brought. Typically, in any case, criminal prosecutorial case, a state prosecutor would be looking at beyond a reasonable doubt whether such conviction charges should be brought and a conviction could be made. So there's a differentiating. The standard of burden of proof isn't necessarily lining up to what would then be put forth in a criminal matter. And then just noting too, one final note that despite a judge reviewing this, and even if a recommendation was made to the Department of Justice to bring charges, that the Department of Justice is not required to then do so. So court is simply just reviewing and making a recommendation.
Thank you. Questions? Senator Abbas.
Thank you, Mr. Chairman, and thank you for taking my question. I apologize if I came in the middle of your testimony,
That's
so
fine.
you may have said this. Is there any concern or opinion perhaps on how this could impact a potential grand jury investigation?
Well,
Well, not
sir-
necessarily investigation, but this grand jury is being held. I mean, those aren't public hearings, but
And that is a great note. So the grand jury hearing is not a public hearing. Any judge that would be sitting on that. So essentially, in this case, anyone involved in this matter from the judicial branch, a judge would be then recused from serving on or overseeing that grand jury because they would have already been aware of the evidence. And again, likely if a grand jury were to recommend charges be brought, charges were then filed, that judge would not be available. And thank you. Your question brought up another note. As to these evidentiary hearings, would they be public or not? It doesn't mention it in this bill. I would argue not, but then it makes note and reference that likely the family who petitioned could be attending the hearing. So there is questions as to would this be a public hearing or not as well.
thank you.
Senator Alshore.
Thank you, Mr. Chair, and thank you, Attorney Warner, for taking my question. So in part of your testimony, you said that, and please correct me if I misunderstood, that there's a concern that the judge reviewing the evidentiary hearing would then not be able to go forward in a future trial. Did I understand that correctly?
Correct, because in any case, a judge can't be involved, can't do external research, no ex parte communications. This type of setting would essentially disqualify that judge from then sitting on the bench of any criminal matter that would go forward with this specific case. So we would need a judge to pull a judge from another county to oversee these petitions and any ones that were filed, or to have, and arguably the workload that this would add would be to have to hire another Superior Court judge solely to work on these matters.
May I follow up?
Mm-hmm.
So I understand that there would be a concern that a judge who did this evidentiary hearing wouldn't be able to do a future trial. But I think the concern is that there's not any charges. So, there can't be a conflict if you haven't even brought any charges. Or I'm looking at part 1 in lines 9 through 12. So the Justice Department opened an investigation, but the Justice Department declared the case closed, doesn't file charges. And then on page 3, lines 3 through 5, the applicability is to cases where the Department of Justice closed the case or declines to retry. So it seems like there's a worry that a judge wouldn't be able to preside over a future trial when the issue at hand is that there isn't a trial and the family needs some information as to why. So it's hard to have a conflict with something that hasn't even happened.
You are correct, Senator. I'm speaking more at the hypothetical then if, say, the judge recommended charges to be brought, charges were then subsequently brought.
Right.
The judge that reviewed that case and made that recommendation could not oversee that trial. So I apologize if that was.
Okay, so that's a problem for the second day.
Correct. I was just noting
Future,
that
that's
is a
That wouldn't be
reason
the
why.
today problem. That's a tomorrow problem because there's already a today.
Correct. That's just to lead to as to why the fiscal note expense of we would require likely an additional judge to not have that problem happen in the future.
Thank you. I didn't get a fiscal note. Did you get is there a fiscal note?
There was
In
one
fact-
attached to the.
In fact, mine says that the LBA was unable to provide a note. So was there one done?
Yes, and pulling the bill on the general court website, it has it available there.
Ah, okay.
Thank you.
Thank you.
Thank you.
Thanks for the clarification.
You're welcome.
Go ahead, Senator Abbas.
Oh, yes.
Thank you, Mr. Chairman, and thank you for taking my question. You kind of alluded to this. So in this scenario, a prosecutor, whether it's the county attorney or AG's office, may decide not to go forward with charges, not because they don't feel like they can satisfy probable cause. It's because they they doubt that they would get a conviction, or they're not confident they would, beyond a reasonable doubt. So therefore don't go forward, which, there's some ethical considerations to go along with that as well. And if this became law, I can understand that it would kind of force a complaint to be opened. So are we asking the prosecutors now to advance a case that they don't feel that they have evidence to reach a conviction on?
I would likely leave that to the Department of Justice to opine on, but essentially, I just wanted to know, as you mentioned, Senator, the burden of proof used here, probable cause, would not be what is used in a criminal case, and what would then also subsequently lead to a criminal conviction. So there is some differentiation. The judge could review this and say, yes, there's probable cause, but still that wouldn't necessarily rise to the level of a beyond a reasonable doubt, which would be required to convict an individual of that charge.
Well,
But to get an arrest warrant, we're going through the same standard here. So what I'm asking is, if the prosecutor their office does not feel that they can get to the end point here, and we're dealing with, homicide cases, which, many of those go to trial, if they don't feel they have the evidence to convict, is this requiring them to go forward? That's how I kind of read this.
How I read the bill, and please correct me if you see this differently, was essentially the judicial branch, the judges would review and use the probable cause standard as a recommendation, but ultimately, despite even a judge recommending there was probable cause to pursue charges, the Department of Justice still has the ability to not move forward. It would ultimately leaves it in the hands of the Department of Justice. But yes, I could agree that could leave more pressure on the Department of Justice receiving these recommendations.
Thank you.
thank you for your testimony.
Thank you.
J.E. Simkin. Good afternoon, Mr. Simkin. How you doing?
Good afternoon, Senator Gannon and members of the committee. Thank you for giving me an opportunity to testify. In the interest of candor towards the tribunal, I am not now, and I have never been an attorney. I'm neutral on this bill. It seems, though, to me as a layperson, that there's a constitutional dimension here. Prosecutors are part of the executive branch. Judges are part of the judicial branch. So that I wonder how it is that a judge can get involved in making a determination of probable cause, which determination usually is the province of the prosecutor. I just raised that as a question. I heard Senator Birdsall say that other states have enacted similar laws, but I wonder if those laws have come before the U.S. Supreme Court for review, or whether they have even come before a state Supreme Court for review. I think that question ought to be answered. Further, it seems to me that this bill, if enacted, could in effect disestablish self-defense as a proper reason for use of lethal force to abate imminent lethal peril. We don't have in New Hampshire, as near as I know, a stand your ground law. We do have the affirmative defense of I was in imminent lethal peril and I had to use lethal force. What happens if a judge who presides at a hearing, if this bill's enacted, doesn't believe in affirmative defense at all, it doesn't believe in the doctrine, or doesn't believe that a person acted truly in self-defense? So a person of interest or a person who has been investigated thoroughly has to bear the cost of legal counsel to be able to prove before this judge or a judge that indeed they acted legitimately in self-defense. These costs are not trivial From my own experience, I know the costs are huge, and I've never been arrested in any jurisdiction, domestic or foreign. But in 2009, the Commonwealth of Massachusetts summarily revoked my temporary non-resident license to carry firearms. It took 3.5 years of litigation and about $125,000 in attorney's fees and costs before we got a unanimous order from the Supreme Judicial Court of Massachusetts restoring the license. I mention this not because I expect any sympathy, but rather to make the point that providing for a hearing without some recognition of the costs involved can make the hearing, in a sense, meaningless. How many folks will have the money to have counsel with them at the hearing, the evidentiary hearing, that Bill 625 FN will cause to be held? And there's a third point. If a judge recommends to a prosecutor that you need to take another look at this matter because I think there is probable cause, how likely is it that a prosecutor who is going to be before that judge, inevitably, is going to disregard the judge's, quote, recommendation, end quote? In short, I think this bill, if enacted, sets up tensions and conflicts. So I understand the purpose of the bill, but I wonder if there's not another way to achieve the bill's objectives without creating some of the difficulties that I think will be created. At this point, I'll be happy to take any questions. Thank you, Mr. Chairman, and I hope you can resolve this, but you volunteered to analyze and cut Gordian knots. You're welcome.
Thank you, Chairman Gannon, members of the committee. I'm State Representative Matt Savorn D. here from Rockingham District 30. Appreciate Senator Birdsell bringing this piece of legislation forward. With me today is a member from my district who is in this exact same situation right now. This is Miss Anna Randall. She wants to tell her story to the committee today, and I'm here for support.
I've never done anything like this before.
That's okay.
And I'm a nervous wreck. I just wanted to tell my story that this bill needs to be put through because I had no evidentiary evidence at all of my son's brutal murder. My son, Christopher, he was murdered in 2021 by Garrido Fort, who he had shot 2 people, not just my son, but he also shot Richard Jambin Jr., who is now disabled for life. He didn't die, but unfortunately my son died. I don't know where to start with this. I mean, where do I start? Where do I start?
Just talk to us. You don't need to read anything. It'll work out better. I know the story. I'm familiar too, so if you can.
Okay, well, Garrido Fort is a many-time over felon, okay, many times over. He's had several felonies for assault and battery, for kidnapping, for restraining orders. Matter of fact, when this happened, he was on a current restraining order from Massachusetts. First, he wasn't even supposed to have a gun, never mind being over state lines from Massachusetts in New Hampshire. Why was he not in jail in the first place is beyond me. Garrido Fort did not live at that house. He was shacking up with Amanda Lovejoy, who was the granddaughter of the owner of the house, Richard Jambin Sr. And she bought 2 guns she knew he was a felon. Why she wasn't arrested, I have no idea either. But anyway, she bought 2 guns, and one of them was actually bought with Fort's credit card. Go figure, he's a felon, not supposed to have a gun. Why wasn't the gun shop? I don't have any evidence of any of this stuff, but the gun shop never asked for his identification or anything. Why they bought 2 guns, I don't know. Anyway, the morning of November 1st, 2021, Fort came out of that house, after stewing all night long. I guess I ought to start there first. On October 31st, okay, supposedly my son scuffed the car that was in the outside of the driveway. It was on the street. It was the older car, it was a 2004 Nissan. And I don't know if it happened or if it didn't happen. I don't know about that. But even though it was a scuff on a mirror, okay, Chris wasn't even aware of it. The reason why I know that he wasn't aware of it is because I was on the phone with Chris that night, October 31st. We're talking about Halloween and going out trick-or-treating with his daughters and all of that. Anyway, he said he had to get ready and blah, blah, blah. He was in a hurry. So I was on the phone with him, and while I was on the phone with him, he got a text from Anthony. The text said that Tony, Garrido Fort, Tony was irate. He was prancing back and forth, saying that Chris hit his car and he was going to get him and blah, 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 that this was an issue, okay? Chris told me, he said, Mom, hold on for a minute. I'm going to go outside and check on the car and see if I hit him. I didn't know if I did it. It's fine. So he went outside. While I was still on the phone with him, he went outside. He looked at the car. He didn't see any scuffs that were out of the ordinary. He says, I don't think I hit it. He says, hell with him. I didn't do, explicit. Okay. He went back in and he says, oh, never mind. I said, what was that all about? He says, the guy, that's staying up there with Amanda, the guy that's staying up there, he's saying that I hit his car. I said, okay, did you? And he says, I don't think so. If I did, I don't know about it. He says, I didn't see anything. I didn't feel anything. Anyway, that ended that. So he just ignored it. Like, okay, it didn't happen. Or if it did happen, oh, well, it wasn't a big deal. It's a scratch on a mirror. Okay, so that was the end of that. So that was October 31st. Now, the next morning, Chris went to Anthony's they were getting ready to go on a job. Okay, they were leaving for Ossipee. So he was cleaning out the seal tank. He was on the back of the truck, all of that stuff. Fort came out of the house that next morning, after stewing all night long. So this is premeditated, if you ask me. He came out of the house with a loaded gun. He had a hoodie on. The gun was in his hand, in his hoodie. He came out of the house. He confronted my son. He had cameras up on the deck upstairs. The camera was there because this man was obsessed with the car, obsessed with this car. Anybody go near that car, there was all kinds of problems and issues, and there was other incidents that happened prior to that. So he went and confronted Chris. There was something, I think, that he had hit Chris that he didn't know it with the gun because there was a noise on the video, couldn't hear it. Anyway, long story short, they started yelling back and forth at each other. Chris is like, I didn't hit your car, blah, blah, blah. They started yelling back and forth. He had the gun, and he had it out of his pocket like this, showed Chris the gun. Chris had something in his hand. I don't know what it was. It's the thing from the seal tank that he was cleaning inside of it. So he did have that in his hand. But, we're talking self-defense, supposedly self-defense. Where's the self-defense? My Chris it should have been self-defense for him. Anyways, he got out of the truck. They argued back and forth. And all I know is that Chris was at least 6-7 feet away from him. They argued. Little Richie came out of the house trying to protect his father and him. And there was 2 shots. Richie got shot in the stomach and my son got shot. He was unarmed. His hands were up in the air, and that's why the bullet went this way and went through his heart and his lungs, and he died instantly. Now, the coroner determined that was a homicide by the state, okay? Benjamin Agati, the Attorney General, said, oh, it was open and shut case. There was no issue in his mind at all that this was manslaughter. If the very least, it should have been manslaughter or whatever. Okay, and he was a felon in possession of a firearm, so there was these all things. And because there was these other incidents that happened a couple of weeks before the murder happened, where he held a gun, that same gun, to Johnny Marshall's head and threatened him to get away from the gun, threw his bicycle across the road. There was an incident where he beat the heck out of Brad Baxter with the gun. I have pictures of him on my phone, bloodied to bits. Okay, so he pistol whipped him. Okay, with that, he also, young Rob Eaton, he also threatened him with the gun. He threatened the children next door with that gun. All these incidents happened before. He was loaded, ready to shoot. He wanted to kill somebody, and my son was the one that he was after. Anyways,
So if we can focus on then, I appreciate and I feel terrible for you. When who contacted you and said they weren't going to
well,
do any charges?
the
If we
Attorney
could get there.
General's office
Yep.
contacted me. At this point, there was a advocate, Amy, was her name, and she called me up and said that there was going to be a meeting. Okay, so we had a meeting, and I knew something was up because at this meeting there was tissue boxes. She knew that I was going to cry or whatever, and they all had this solemn look on their face. So he says to me, I hate to tell you this, Miss Randall, but there's not going to be any charges brought against Ford. I almost passed out right there. I said, what do you mean? A week ago, so you told me this was a slam dunk. There was no way. There was video evidence, everything. There was no way that he wasn't getting charged with something, you know? Well, he wasn't. He didn't get charged. He says, well, we're not bringing, we can't prove that it was a self-defense. I said to him, I said, isn't self-defense something that you have to have in front of a jury? Isn't that a defense? Okay, once you get charged, then it's up to them to prove it, self-defense. Okay, well, he says, not in this case. We can't disprove it. I don't want to bring a case to something that I may not be able to win. I was like, isn't that a jury's? That's for the jury to decide whether you're guilty or not. Just bring the charges and let the jury decide. That is where my problem is right there. I have no justice. I have no proof. They wouldn't show me anything. All I got was a death certificate that said my son was killed by homicide. Okay, I have no proof of anything. They wouldn't give me any information. They wouldn't tell me anything other than, sorry, we're not doing it. So they brought no charges against him for anything. Okay, and then now he's in jail for the federal having a firearm. Okay, now I have word after word after word of testimony from the federal court that says that in the federal court there should have been a homicide, but they did not have the jurisdiction. It had to go to the state. The judge in the case also, he was beside himself that the state dropped the charges on him for not only the state gun charge, but for the assault on Brad Baxter and for the criminal threatening on Johnny. The state dropped all the charges on Garrido Fort. All of them. Dropped them all. Just like, okay, nothing happened. So I'm like, what about the shooting? Nothing. It's like the shooting didn't happen. Okay, this is wrong on every level. All I'm asking for is that charges be brought. I want the Attorney General's office to be held accountable for this because I am a mother of a dead child, okay, and the grandmother of 3 granddaughters that lost their father brutally, and they have no justice. There's no justice here. Please, that's all I'm asking is that this goes through, that we can find a way to have a trial. I want him charged and have a trial, but we can't do this without this first step.
Thank you for your testimony today. Questions? Our condolences. We're sorry. Thank you, Representative, for coming today. Appreciate it.
Thank you.
Donna Sheehy? Lieutenant Stephen McAlvey. Am I the right one still? Oh, sure. I'm sorry, Donna. I didn't know that was you.
It's okay.
Go ahead, Ms. Sheehy.
Sorry. I'm within. So there were some things you left out.
Just turn your microphone.
There's a button right in front of you on that mic. When you see the red, you're good.
Okay. There were some things that I wanted to add that she left out of it because I know she's upset. And so am I, because he was like a nephew to me. I've been friends with Anna for like 39 years. So our kids grew up together. So I knew Christopher since he was probably like 6 years old, 7, whatever. Anyway, this guy had a very long, extensive history of violence with guns, etc., etc. Like, I mean, in Massachusetts, he had a long criminal history of violence, like restraining orders, kidnapping, resisting arrest, you name it, he had it on his record long before this ever happened. So I just think that that should be added into the equation, that he was a very violent person. You're welcome.
Good afternoon, Mr. Chairman. Good afternoon, Senators. Thank you very much for being able to take. My name is Benjamin Agati. I'm a Senior Assistant Attorney General at the Department of Justice. My intent is to just briefly address the bill itself because I think that's what we're here for today. With regards to other facts of matters, I'll refer to final reports that were issued by the Department of Justice on those matters, so I'm not going to go into those right now. There are 3 issues, I think, that with regards to this bill, the Department of Justice is neutral. It does not take a position with neither for nor against this bill. But I do want to point out 3 things, and that's the reason why I came over to be able to testify today and answer any questions that you might have. Those 3 things are as follows. First of all, this is going to be a very expensive bill, as you can see from, or at least on the court's website, you can see the 2 different fiscal notes that were attached. This puts, if you add in the costs of what this would take with regards to Department of Justice as well as from the judicial branch, you're talking about close to $1 million per year in order to institute this system. Separately, there is already a system that is in place to address the materials that were shared and that do get shared in 91A in our final reports. You can find all of our final reports that go issue on the Department of Justice website, but most importantly, this particular bill as it's written causes 2 problems with regards to the constitutional concerns, some previous testimony that you've already heard about. If this statute were passed, what it would essentially be doing is asking the Superior Court to issue a recommendation. That is an advisory opinion. And under Part 2, Article 74 of the judicial branch, the only advisory opinions that the entire branch may issue is ones issued by the Supreme Court, and those must be in responses to questions of law that are asked directly by the legislature or by the governor and the executive council. So this particular statute, as it is written, would run afoul of that because it is asking the Superior Court, not the Supremes, the Superior Court to issue advisory opinion on facts and the applicability of facts. That runs afoul, so a constitutional amendment would be necessary in order to make this statute applicable. Separately, and I know that this committee, I believe, maybe roughly 8 or 9 years ago, heard about a different constitutional amendment that would allow for a victim's family to be an intervener. That would be, I believe that was something that was already brought in front of the legislature. That would have to be brought again. You're talking about 2 separate constitutional amendments to make this statute applicable. And then the only other thing that I have, and then I'll take any other questions that you might have, is with regards to the term of homicide. The term of homicide is used by the Office of the Chief Medical Examiner is a medical definition, not a legal definition of homicide. It is 2 different ones. We actually go to great lengths to try to explain that when we meet with folks. That homicide means that it came at the hands of another. This statute is written, for example, other homicides you might think about would be matters where an officer has used deadly force with regards to a suspect. That is a homicide investigation that we do. It's a defense, just like other defenses that have been talked about here in testimony today. But the initial finding of homicide with a medical examiner is a medical finding and of a medical term, not the legal finding. So different things in terms of how it's defined by statute versus how it's defined by the Office of the Chief Medical Examiner. Those are the only things again, the Department of Justice is neutral with regards to this bill, but I'm happy to take any questions at any time.
Senator Abbas, go ahead.
Thank you, Mr. Chairman, and thank you for taking my question. So I understand there's some cases that are not brought forward because of an issue of perhaps of you don't believe you can meet your burden of proof. In cases where you don't bring the charges forward because of the potential of an affirmative defense, I can appreciate that, but I guess I know you've prosecuted murder cases and homicide cases in the past. And on those cases, I'm not asking you to discuss anyone specifically. Does new information ever come out during those trials that wasn't known during the investigative period?
During the trials, sometimes it has. I can tell you, for example, one trial that I tried, we had no indication that there had ever been a video of a defendant's confession, only that it was on audio. And it came out literally during the testimony of one particular officer that there had been a video system running. That was unknown to both us and defense counsel. So I can't say that it never comes out, something like that, but the substance was already known. One of the matters that you've already heard about from some testimony starting at the beginning of hearing testimony on this particular bill did involve something like that, where the original event was in 2017. New information and concerns were brought to light by 2020 by police personnel, and a reinvestigation was done. So it is routine that if new things come up, then reinvestigations do occur, and those need to be ferreted out to their conclusion, whatever that may be.
Well, thank you, Mr. Chairman. But when you're dealing with an affirmative defense, that is essentially the person who caused the murder, the homicide, is not really being questioned. It's just whether their actions were, was it actual murder or was it lawful self-defense? I mean, that is an affirmative defense, is certain that.
Certainly, it may be an affirmative defense. There also may be other conditions that would change that. So, for example, immaturity, insanity, incompetency, all of those may play a factor in regarding not so much insanity and incompetency to go forward. Department of Justice still brings charges like that, and so does the county attorney's office. But in the matter, I can think of immaturity, where we've had a few of those in the state, that would also play into why charges would not be able to be brought forward as an adult.
Last follow-up.
Go ahead.
I'm just asking, just even a hypothetical fact pattern, when an example of a case you would not bring charges forward because someone you believe is going to assert an affirmative defense to the charge.
Certainly. So in those instances, and certainly ones that have happened in the past from the Department of Justice, we make the indication that we are not able to bring charges forward because we cannot prove our case beyond a reasonable doubt. And a final report is issued that explains the facts of those materials. They're able to be released under 91A, and then the explanation for why the charges are not being brought is written inside that report. And I apologize if I'm not answering the senator's question.
What I'm getting at
directly.
is, there's a belief that the person is going to claim self-defense, whether they said that in an interview or whatnot. It has to be asserted. What I'm asking is, if that's the case, just because someone's asserting it, even prior to the charges being brought, the cases aren't being brought forward. That's different than simply lacking evidence you think they can meet the conviction, as opposed to thinking they won't be convicted because of raising an affirmative defense. So what I'm asking is, can you just give me a hypothetical fact pattern where someone would assert an affirmative defense, but you still would bring it forward? Unless they're blatantly lying, it's on video. I understand.
If there was a situation where, so I want to make sure I'm understanding the question correctly. If there was a situation like that where an individual was asserting a defense, an affirmative defense, but the evidence did not show that that is true, then the state would be bringing charges forward. Oftentimes, people may claim that they are justified in their actions, that it's a self-defense or defense of another, when that is not the case. The evidence does not bear that out, and so the Department of Justice or another prosecuting agency would still continue and bring forward the charges. In matters in which the state sees that the Department of Justice sees that we could not disprove that the evidence is not sufficient to meet our burden at trial, we would not go forward with what those charges are. That is primarily goes back to our ethical obligations that we have under Rule 3.8 under the New Hampshire Professional Conduct Codes, as well as the additional oaths that we've taken as attorneys not to bring forward a frivolous action. So if we know that the action does not have a chance of success at trial, we have to do that. It's very similar to the prosecutor's duty to ensure that a defendant is aware of what their rights are, or that the court is aware that if there has been a violation of the rights, as officers of the court, we must bring those forward to the counsel, to the judge. It's not the same as when we are, let's say, a private counsel or a defense counsel, where our obligations are to act in the best interest of our client. A prosecutor's actions are to act in the best interest of justice and the application of the law, whatever that is. So it's a different obligation. And so as a result, if we feel that we can't prove it beyond a reasonable doubt, then the state has not brought those charges forward.
Thank you.
Go ahead, Senator Ridden.
Thank you, Senator Gannon, and thank you, Attorney Agati, for taking my question. I'll apologize that I came in late, so let me know if I've missed something here. When that report is issued, is that mean never, ever again? I mean, is that with prejudice? Or is it that at some point you could learn something else and those charges could be brought?
It is the latter, exactly. If there is something else that is learned, then those could be changed at any point in time. If we find out that there is new information, again, some of the testimony that this committee has heard earlier involved a matter from 2017 where new issues were brought to light in 2020, and that triggered a reinvestigation. So no, that doesn't mean that there is any sort of preclusion for all time with regards to that.
Thank you.
Thank you for your testimony.
Thank you, Senator.
Does anyone else wish to testify on 625 who didn't write in, or seeing no one, will end the hearing on that bill? I'm doing a quick one with 66. You'll make it. You got it.
All right, we will now open the public hearing on Senate Bill 466, and this time the chair recognizes Senator Bill Gannon to introduce the bill as the prime sponsor.
Thank you, Senator Abbas. Before I start, it'll be very brief. I'm going to come forward with a committee amendment which sort of changes the whole gist of this. It's not the fact that someone removes or does the alteration to a serial number. We're going to change the bill to say it's a felony to possess such a firearm. And I'm going to let the good officer explain further.
Good afternoon, dear Senator, Senator Abbas, members of the committee. My name is Rob Gravel. I'm a captain with the Manchester Police Department. I've been employed as a police officer for almost 28 years. I'm here to testify in support of Senate Bill 466 relative to the possession of a firearm with obliterated serial number identifying marks. This bill would make it a Class A felony to possess a firearm with destroyed identified markings. When a firearm is stolen, the serial number can be entered NCIC. It's a nationwide computer database that allows law enforcement agencies to determine whether or not the firearm is stolen. When the serial number is destroyed or altered, this process cannot happen. Possession of a stolen firearm carries a penalties equivalent to a Class A felony. However, under the current law, a person possessing a firearm with an obliterated serial number faces a Class A misdemeanor, effectively rewarding the destruction of the serial number. Serial numbers are critical for tracking the purchase of firearms. A straw purchaser can remove the serial number, sell, trade, or allow another person to use a firearm without being traced back to the original purchaser. This anonymity allows illegal activity to continue unchecked. The ability to trace a firearm back to its purchaser is essential for identifying straw purchasers and conducting further investigation on this. An obliterated serial number makes this impossible. In closing, I respectfully ask this committee to find Senate Bill 466 ought to pass. Holding criminals accountable can only help make our state safer. Thank you.
Thank you, Mr. Vice Chair. Thank you, Senator Gannon. Could you, one more time with the amendment you want to bring forward?
It hasn't, we're gonna change the wording, so it's the fact of possessing. It isn't the fact that you're obliterated. Mere possession is gonna be the word shall possess. So if anyone possesses this type of weapon without the serial number on it. So we're not, because we wouldn't know who, you might find someone, you won't know if they were the one who changed the serial number or not. So it's the mere possession.
So that's line 5.
Well, it's really gonna be line 3, I think.
Okay.
No person shall possess. And then I'll get rid of the alter, remove, and obliterate parts. And that'll be the guts of the
May I
bill.
follow up?
So it's mere possession.
Would it not be appropriate to add in the word possess after the word shall and keep everything after that?
You can answer. Go
Okay.
ahead.
Yeah.
Yes,
Yeah.
that's what possess a firearm. It doesn't matter who changes it.
Yeah.
It would be if you possess a firearm. So no person shall possess, change, alter, remove, or obliterate the name, make, model, manufacturer's number, or other mark or identifying mark on any pistol, revolver, or any other firearm.
Okay, thank you. Got it.
What he said.
What he said.
Yes,
If I could just ask, so
Sure.
you may have heard the term ghost guns in the past.
Yes.
And basically, people that are much handier than myself somehow are able to build their own. That wouldn't have a serial number, what I understand. So in a case like that, I think under the current law, that would fall outside of this. I think this addresses a firearm that has a serial number, then someone tampers with it. Would your
Yes.
amendment expand the scope of this to apply to a ghost gun?
This is only for a firearm that should have a serial number that's been defaced off of it, sir.
Thank you.
Thank you.
Can I follow up?
Senator Ridden.
Thank you. If you wouldn't mind one question, is there another law that says possession of a ghost firearm is a crime?
Not in New Hampshire. There's no state law.
It'd be federal law.
Yes, that's federally prohibited to have a privately manufactured.
Thank you.
Seeing no questions, thank you both for your testimony. Are there any members of the public who are present who wish to speak that haven't spoken already?
Yeah. Hi, Mr. Simpkin. We didn't mean not to include you.
Just please state your name for the record.
Good afternoon, Mr. Chairman and members of the committee. Thank you for giving me an opportunity to testify. I have held a federal firearms dealer's license, Type 01 retailer, for a shade over 40 years, about 33 of them here in New Hampshire. This bill, if enacted, basically replicates a federal enactment codified as 18 U.S. Code, Section 922, K for kilo. This bill, I think, needs some amendments, which I think will make it more useful. To begin, I want to convey to you something that is not widely known, and that is there are no federal regulations of which I'm aware, and I've inquired diligently, that require a party that ships a firearm in interstate commerce to enclose with the firearm any documentation with the firearm's particulars, the type of firearm, the maker's name, the model designation, if there is one, the caliber designation, if there is one, and finally, the serial number. So there is a tendency to assume that in the keeping of all of these records, there is some sort of uniform standard. There may be, but a 20-year ATF industry compliance investigator told me that he didn't know of any such standard, and I've never found it, and I have looked. So, here are the amendments I suggest. The bill should recognize explicitly that prior to enactment of the Gun Control Act of 1968, there was no requirement that a firearm have a serial number. Therefore, there are millions of firearms that never had a serial number, and those are completely lawful to own. The reason for including this in the bill is to preclude allegations being made that a firearm that never had a serial number has somehow had the serial number removed. Showing that the committee is aware that there are many firearms that never had serial numbers will reduce the risk of someone having to prove just that. This firearm in question was made without a serial number. Just finding an expert to testify that, say, a Stevens shotgun made in 1953 and sold by Sears under its own name didn't have a serial number would be hugely expensive. These folks exist, but there aren't a lot of them. Okay. Second, at the start of the bill's second sentence, the word knowing should be inserted. This will align the bill's language, which provides, and I'll quote briefly, K, it shall be unlawful for any person knowingly to transport ... any firearm which has had the importer's or manufacturer's serial number removed ... Knowing should be in this bill so that it aligns with the federal enactment. I also point out that there are serial numbers on firearms that are not in plain sight. So you would look at it and you would say, well, there's no serial number on this firearm. I had a Derringer come through several years ago that had what I would call an occult serial number. It was under one of the grip panels. Grip panel was made of ivory. Ivory is now a controlled material. So I had the delicate task of removing that grip panel to verify that the serial number that the shipper stated was on the weapon actually was there. I point out most firearm dealers are not gunsmiths and therefore normally shouldn't dismantle firearms at all. So there can be situations where someone could be charged again with removing a serial number and serial number is present. Third, and critically, there needs to be an exception in the bill for a firearm that has corrosion damage to the serial number or other markings. At the risk of laboring the obvious, there are tens of millions of firearms with frames or receivers made of steel. I don't want to insult anyone's intelligence, so I state for the record, steel, if exposed to water or humidity, rusts. And in extreme cases, rust can make illegible part or all of a serial number. Not theoretical. I was once asked to take possession from a police department in Massachusetts of a firearm with a rust-damaged serial number. I declined because I have no lawful authority to possess such a firearm. And that leads to my fourth suggestion. The bill needs to have an explicit exemption for law enforcement officers in the performance of their official duties. That will shield them from prosecution if they seize a firearm that has had its serial number or other marking deliberately damaged or defaced. Without that protection, were I a peace officer, I would not take possession of such a firearm, even when a court's order so requires, because I have no lawful authority under this bill. The bill says no person. Can't be clearer than that. So these are my suggestions to improve the bill. And I understand that the federal authorities, who obviously can lawfully prosecute someone who has a firearm with a deliberately damaged, obliterated serial number, they have lawful authority to do that. I would sort of like to know how many of those prosecutions there are that are standalone, where the only act alleged by the federal authorities is, well, you've got this revolver with the serial number ground off. Otherwise, nothing else. I suspect, said Simpkin, tiptoeing out on a slim limb in a stiff breeze, there are very few such prosecutions because they're expensive in terms of a prosecutor's time and investigator's time. At this point, I will be happy to take any questions on this matter.
Seeing none, thank you for your testimony.
Thank you.
Does anyone else wish to testify on SB 466 who didn't put their name down? Seeing none, that'll end the hearing. Okay, we're going to start the hearing on SB 555, an act relative to critical risk protection orders. Welcome, as always, Senator Deb Elschler. Good to see you.
Thank you very much, Mr. Chair, and honorable committee members. For the record, my name is Deborah Altschuler. I represent Senate District 24, including the towns of Exeter, Greenland, Hampton, Hampton Falls, Northampton, Rye, and Stratham. Senate Bill 555 is a public safety bill designed to prevent suicide and save lives in New Hampshire. Suicide is the second leading cause of death for New Hampshire residents aged 10 to 34, and the statistics are stark. 50% of suicide deaths in New Hampshire involve firearms. Firearms are used in 89% of all firearm-related deaths in our state, and when someone uses a firearm in a suicide attempt, it is lethal 90% of the time. 90% of the time. Between 2015 and 2020, 55 male suicides and 55% of male suicides and 28% of female suicides involved firearms. For our veterans, 71% of armed forces members' suicides involved firearms. Self-reported suicidal ideation among high school students increased between 2011 and 2019. Between 2020 and 2024, gun violence claimed 722 Granite Staters by suicide and 84 to homicide across our 10 counties. In your packet on page 2 is a graph of the 10 counties. And the line in blue shows how many firearm deaths were by suicide and how many by homicide. There is a gap in our laws. We have 3 existing statutes that temporarily restrict firearm access. The first, domestic violence restraining orders, 173Bs, where they require a crime has been committed. 2, stalking orders, 633.3, requires that a crime has been committed. And 3, involuntary commitment, 135C, an extremely high bar requiring handcuff transport to a facility for psychiatric evaluation. What about the families who see warning signs before a crime occurs, but they don't meet the threshold for involuntary commitment? Currently, the only option available is a wellness check. And we know from previous testimony in this chamber and in the House and in the newspaper and in our courthouses that it's not enough. This bill fills that gap by creating a civil order. It's not a criminal order that allows family members, household members, and law enforcement to petition the court when someone exhibits warning signs and possesses a significant risk of harm to themselves or others. The process requires a petition demonstrating a pattern of behavior indicating significant risk. It requires a court hearing with due process protections. It requires clear evidence of danger to self or others, and it gives temporary removal of firearm access while the person gets help. This is about creating a tool for intervention during crisis, not permanent firearms removal. It's a speed bump between crisis and catastrophe. We have addressed similar crises before. Consider our opioid response. In 2021, 382 people died from opioid overdoses, 87% of all drug overdose deaths. We didn't surrender. We didn't throw up our hands and say, oh, well, what are you going to do? We formed task forces. We trained community members in naloxone administration. We issued standing orders for naloxone at pharmacies nationwide, and we created comprehensive harm reduction strategies. Does naloxone stop people from using opioids? No. Does it save lives? Yes. Does a task force stop people from using opioids? No. But it does help us save lives. We don't ask whether seatbelts would have prevented this specific car accident. We don't debate whether raising the drinking age prevents every drunk driving death. We know that comprehensive public health strategies work. These are real Granite Staters, real tragedies. In my district, George Tilton was hospitalized 3 times for suicidal ideation. Police took his first firearm when a friend reported that he was suicidal. The Exeter police came to George's home and asked him and did a wellness check And he ended up telling them that he had purchased a firearm and he had it in his glove compartment and he was having suicidal thoughts. He willingly gave his firearm to the Exeter Police Department and then subsequently checked in for psychiatric treatment. George wouldn't be able to get that gun back without a court order, you would think, except he could. He could do it the very next day because no crime had been committed. And without a critical risk protective order, George can also go buy another gun, which is exactly what he did. He took cash out of his bank account. He left his firearm with the Exeter Police Department. And after he got out of the hospital, he was fined for a little while and he took money out of his bank account. His mom noticed because they were on a joint account, asked him about it. He was struggling. And he said, oh, I was using it to pay a bill. Actually, I took money out to reimburse a friend to pay a bill. But really what he had done was taken out $650 and gone to a federally licensed firearm dealer where he purchased a gun legally while he's in crisis, while other people knew he was in crisis, because we don't put any speed bumps in front of that. And so George wasn't interested in hunting. He wasn't interested in marksmanship. He actually had never even fired a firearm. His only purpose in obtaining a firearm 2 times was to ensure that if he attempted suicide, he'd be successful. And despite multiple episodes of suicidal ideation and George's hospitalization and many medications, he fired his firearm for the very first time in a parking lot in Dover into his head, his first and only suicide attempt. The Dover Police Department found him. It's the last thing he ever did in his life. He was 23 years old. His parents still live in my district. In August of 2024, Brittany Weston and her 8-year-old son, Benson, were murdered in Troy, New Hampshire, by Brittany's husband. I'm not going to mention his name because I think the victims deserve their names said out loud versus the perpetrators. The medical examiner determined the cause of death was multiple gunshot wounds to the head. 8-year-old Benson's lifeless body was found in a car on the Piscataqua Bridge. He was shot to death. In August of 2025, Ryan Long of Madbury was shot to death by his wife. She also killed their children, 8-year-old Parker and 6-year-old Ryan Jr., before turning the gun on herself. That this woman was severely struggling was not unknown. She had been documenting her declining mental health on TikTok for the world to watch. The warning signs were there. The tools to intervene were not. In October of 2025, Cindy Moody and her daughter Crystal Moody of Bath were shot to death by Cindy's brother-in-law. He had been struggling with suicidal ideation, living in a home with high tension and ready access to firearms, a deadly and sadly not uncommon combination. 6 months before killing 18 people in Lewiston, Maine, the shooter's son reported his father's extreme paranoia to police. 4 months before that, the perpetrator had been hospitalized, and 1 month before, his family had contacted law enforcement for a second time. Had this happened in New Hampshire, there would be no legal tool to intervene. We don't have to live like this. We don't have to have, shouldn't have to stack up more stories, more bodies to get this legislature to do something. We shouldn't let another opportunity pass to do meaningful gun violence prevention work. 22 states and have already enacted similar laws. They recognize what we must. Families and law enforcement need tools to help people in crisis before tragedy strikes. And Senate Bill 555 creates that tool. It empowers the people closest to someone in crisis, the ones who see the warning signs, the ones who hear the threats, the ones who feel the danger, to take action through the courts to temporarily restrict access to the most lethal means of doing harm. This isn't anything about taking away rights permanently. It's about saving lives temporarily while someone gets the help that they desperately need. And I respectfully ask this committee to give Senate Bill 555 an ought to pass recommendation. Included in my testimony is a fact sheet from the Johns Hopkins Center for Gun Violence Solutions. And I believe you also have testimony from the Johns Hopkins Center for Gun Violence Solutions. And you also have testimony in support from the New Hampshire Psychiatric Society.
Thank you, Senator. Question for you. Under
Yes.
temporary relief, you have that you can give,
What number, where are you?
I'm sorry, G4, around lines 19 through 21.
Page.
The for a temporary relief, you could do it without notice to the actual respondent. Wouldn't that be denying him notice and an opportunity?
That's what we do in domestic violence cases.
Okay.
It's already how we proceed with 173B.
Thank you.
So the process is in place, and the courts have been know how to do this and know how to deal with this.
Thank you. Senator.
Thank you for the question.
No, we're all set. Thank you.
All right, thank you.
Mr. Simkin.
Good afternoon, Mr. Chairman and members of the committee. Thank you for giving me an opportunity to testify on Senate Bill 555. I state for the record, I am a federally licensed firearms dealer and have been so for over 40 years, slightly more than 30 of them in Nashua, New Hampshire. This bill, if enacted, furthers a lethally dangerous fraud that court orders and protective orders can help someone in lethal peril. This bill has foundational flaws that can't be fixed, and I suggest it be voted inexpedient to legislate. First, firearms abundance foredooms efforts to keep firearms away from those who are criminals or lunatics. Second, the U.S. courts have ruled that police forces have no duty to protect the law-abiding. And third, New Hampshire, with very few laws as to firearms, remains one of the safest states in the United States. So, as to the first point, at the end of 2023, there were approximately 512 million firearms in the United States. This total is based on data published in official publications by the U.S. Treasury and U.S. Department of Justice. In my prepared testimony, I state in a very granular way the specific publications on which I rely. The idea that an enactment of this sort is going to stop someone intent on suicide or murder from getting a weapon is, bluntly put, absurd. Someone who intends to commit suicide or who plans to commit murder need not come to me, a federally licensed dealer. There are many, many millions of firearms out there. So the effect of this bill, if enacted, is to perpetrate a myth that, oh, we enact this and the person can't get weapons. They can get them and they will get them. The reason is simple, but I'll state it for the record. The supply of weapons is infinitely large relative to two micro-minorities, criminals and the wafer-thin slice of the mentally unwell who are dangerous to themselves and others. If enacted, this bill will ensnare many falsely accused of wrongdoing. And contrary to the testimony you've heard, they will never regain their civil right to be armed because once they're in a federal database, the Supremacy Clause of the U.S. Constitution will, as a practical matter, make it impossible for them to get their name removed because the feds do not have to do anything in response to a request by the state of New Hampshire to remove a person's name from the databases that, if consulted, will show the person can't own firearms. Second point, gun control is a concept alien to U.S. jurisprudence because, I repeat myself deliberately, police forces in the United States have no duty to protect the average person. This is old doctrine. It dates from 1855. Here's the doctrine in the modern English of a relatively recent U.S. Appeals Court decision. Quote, but there is no constitutional right to be protected by the state against being murdered by criminals or madmen. It is monstrous if the state fails to protect its residents against such predators, but it does not violate the Due Process Clause of the 14th Amendment, or we suppose any other provision of the Constitution. Period, end quote. Cases Bowers versus DeVito, the citation is 686, capital F, 2, small d, 616, 618, 7th Circuit, 1982. This is good law. This decision has not been overturned. Formally, it only binds federal courts in the 7th Circuit, but other courts can cite to it. More recently, the U.S. Supreme Court has held that even the beneficiary of a court's order of protection or restraining order has no right to police protection. I have the details in my prepared testimony. The relevant case is Town of Castle Rock versus Gonzalez, and the date is 2005. So the idea that there is a legal basis for doing what this bill purports to do is simply error. And on top of that, my third point is that New Hampshire, for almost 40 years, has had an incidence of violent crime that is among the lowest in the nation. Since 2001, we have been in the top 3, with one exception, 2015. And these data are published by the FBI in its Crime Data Explorer. So in short, this bill addresses a problem, but the solution that it proposes is error. What the state doesn't have and needs is a secure facility in which those who are deemed a danger can be placed. We haven't had such a facility, I think, for a very long time. But the notion that folks who have the mindset that Senator Altshuler described can be left at liberty and that they won't get firearms, I'm sorry, I just think that's absurd. and thus I renew my suggestion that this bill be voted inexpedient to legislate. It will not address the problem. I did a little bit of research, I haven't finished it, in terms of bills that have been before the general court aimed at suicide prevention. So I simply used the bill search facility and used the word suicide. There were some such bills, including one aimed at preventing suicide among first responders. I didn't find Senator Altschuler's name as a sponsor or co-sponsor of any of those bills. I haven't finished my research. So, well, I think it's material here because you had testimony from Senator Altschuler using suicide as a basis for doing this. I'm sticking to the bill, and the purpose of the bill avowedly is to prevent suicide. My point is, can't be made to work. And at this point, I will happily take questions. Thank you for giving me an opportunity to present my testimony. And I have printed copies, which I'll pass along.
Chairman Gannon and members of the committee, thank you for the opportunity to testify today. My name is Holly Stevens. I'm the Director of Public Policy at NAMI, New Hampshire, the National Alliance on Mental Illness. NAMI, New Hampshire is a nonprofit grassroots organization whose mission is to improve the lives of all people impacted by mental illness and suicide through support, education, and advocacy. I am here today speaking in support of Senate Bill 555. In 2024, the United States Surgeon General identified suicide as a major public health issue in the U.S. and one that is largely preventable. The impact of a single death is profound and ripples out to the family, friends, schools, workplace, first responders, and beyond. It's important to note that 90% of people who survive a suicide attempt don't go on to die by suicide. And unlike other means of suicide, a firearm in a suicide attempt is almost always lethal and leaves little opportunity for intervention. Given the lethality of firearms, limiting access during a mental health crisis saves lives. While people may contemplate suicide for a long period of time, when they finally make that decision to end their life, there's usually little time between that decision and them making the attempt. Toward that end, temporarily restricting access to lethal means, in this case firearms, is an important suicide prevention strategy and one that is recommended by the National Strategy for Suicide Prevention. In New Hampshire, the rate of gun suicides increased 55% from 2009 to 2018, compared with just 19% nationwide. You heard some statistics regarding suicide in the Granite State, and I just wanted to point out that suicide is the first leading cause of death for individuals aged 10 to 14 in our state. It's the second leading cause of death for individuals 15 to 34, and the third leading cause of death for individuals 35 to 44. Every year in New Hampshire, an average of 124 people die by gun suicides. So simply put, temporarily restricting access to firearms when an individual poses a significant risk of causing harm to themselves or others is a common sense measure in addressing the major public health issue of suicide in New Hampshire. Therefore, we are supporting this bill today, and I'm happy to answer any questions.
Thank you, Mr. Chair. Thank you, Ms. Stevens, for taking my question. When NAMI New Hampshire is looking at suicide prevention, is suicide prevention all leaning on one thing, or is it a coalition of things, an umbrella of things?
It's a comprehensive array of items, doing prevention as well as postvention, and working with individuals and trying to, even something like there's a bill that's going to be heard tomorrow in the House on suicide prevention training for teachers in schools. That's another measure that, getting folks trained, getting police officers trained in CIT training. There's a broad array of measures that we look at going into suicide prevention, and this is just one of them.
Thank you.
Thank you.
The words extreme in this bill were exchanged for the word critical, but this is the same draconian legislation being pushed by a New York City billionaire that has been pushed for several years. They even spent over $1 million to try to push it in New Hampshire, which is one of the safest states in the country, and in 2025 was actually designated as the safest state. This legislation has nothing to do with safety and everything to do with gun confiscation. It's a discriminatory bill aimed solely at law-abiding gun owners. Remember, the people being targeted by this legislation have committed no crime. The petitioners in these civil cases can pretty much say anything about the accused simply to have their firearms confiscated. A petitioner can be an ex-roommate you lived with 2 years ago, and they can call for this to happen. This is a thought police bill where a law-abiding gun owner is accused of maybe thinking about committing a crime sometime in the future. It also gives law enforcement massive powers over the people to take away their fundamental human right to self-defense. As far as suicide is concerned, we've been bringing this up again for several years. If involuntary admissions isn't good enough to get someone who really needs the help to get the help, why aren't we making that law better? Why aren't we opening up or proposing to open up more mental institutions so those who are violently mentally ill can live out their lives in a safe place, safe from themselves and from society?
I'm also concerned why this bill isn't, they're only concerned with gun owners when it comes to suicide. Do the other people who commit suicide not matter? I had a cousin who committed suicide by firearm and a good friend who hung himself. Which one of those lives is more important than the others? Certainly not one over the other. This bill does nothing, absolutely nothing, to get people the help they may need. And that's what we actually need to be done. Not only is this bill completely discriminatory against a large subset of law-abiding granite staters, but it takes away several guaranteed and protected rights. The Fourth Amendment right of privacy, the Fifth Amendment right against uncompensated takings of property, the Sixth Amendment right to jury trial and to confront opposing witnesses, the 14th Amendment's guarantee of due process of law, and of course, granite staters' fundamental human right to self-defense protected by the U.S. Constitution's Second Amendment and New Hampshire's 2A. This bill has absolutely nothing to do with safety. It's about gun control and gun confiscation. Please vote inexpedient to legislate. It's the right thing to do yet again.
You're welcome. Name's Bonnie Downey. I'm resident of Newmarket. Senate Bill 555 is presented as a mental health bill, but it is a gun control measure that does not provide meaningful assistance to those who may be at risk of harming themselves or others. The bill gives special weight to the opinions of family members or close friends, which is misleading. In the field of professional mental health, practitioners do not evaluate or treat their own family members or friends due to the reduced capacity to objectively assess individuals using their expertise and training. They're just too close. As a result, evaluations performed by those close to the person are more likely to be inaccurate. Additionally, this bill does not offer protection for the individuals who may be falsely accused by family members with whom they do not have a good relationship. Being related to by blood does not guarantee a clear, unbiased perspective, yet the bill grants special consideration to these relatives. When a person is deemed to be a significant risk, the bill allows for the removal of their firearms. However, it does not address the broader issue, as the individual will still have access to other potentially harmful objects, such as a knife, a rope, medications, cars. If they're going to do harm, they're going to do harm. Removing a firearm is not going to restrict that. The bill fails to provide real help for the immediate concern, which is the mindset of that individual. To believe that the ending their life or threatening someone else is necessary. In conclusion, I urge you not to pass this bill. It does not support those who are truly at risk, and instead it strips citizens of their fundamental Second Amendment rights. Thank you.
Thank you. Thank you to the committee for hearing my testimony. I'm Lauren Selig. I represent Durham, which is Stratford County, District 10. I want to start with a story. The story of a woman who had a history of making some really poor financial choices in her life. At one point, she seemed to get those choices under control, but then everything in her life began to spiral. She was a mother to 3 young children, 2 in early elementary school and a toddler, and married to a man who contracted a particularly brutal and rapidly fatal form of cancer. My own daughter, now a college freshman, spent the last 2 years of her high school career as an assistant kindergarten teacher in the class where she herself had been in kindergarten. We're from a very small community. My daughter knew the father of that family when he was her school psychologist when she was in middle school. She knew the oldest child from elementary school And she spent her senior year working every other day with the middle child, who was her favorite in the class. She loved the experience of working with that child so much, she debated pursuing a teaching degree. But let's go back to that mother, who by the late summer of 2025 was in a free fall of emotions and began sharing her stress on social media. The way our New Hampshire laws are written, whether or not anyone had contacted authorities, unless she was placed in an evaluative psychiatric hold, nothing more would be done. And on my own daughter's very first day of college classes, I had to call her in the middle of the day. It was a horrific call. I had to tell her that the family that she knew and loved was all dead, except for the toddler. The mother had reached her breaking point. And rather than reaching out for the help she so clearly had needed and had been crying out for in her social media posts, she chose to end the lives of her 2 older children, her husband, and herself by gunfire. We can never know what her final motivation was, but if SB 555 had been in place, when her social media posts were visible, someone could have made the call that would have saved saved their lives. A few weeks before that, there was an incident where a man who was accused of domestic violence and had a restraining order used his own gun to murder the woman trying to end their relationship before turning the gun on himself. And as Senator Altshuler referenced, over the summer before that, a man shot and killed his wife before driving across the state with his child in his car, where he ultimately shot and killed his child and himself on a bridge between Portsmouth and Kittery. All of these could have been prevented with a bill like SB 555, which is first and foremost a public safety bill and an important step. I want to be clear, it's a step. It's not the be-all, end-all in suicide and murder prevention in New Hampshire. Oh, I should also say that my daughter has ruled out education as a career, and when I asked her about it, she said, "Mommy, I couldn't handle losing another student." Senator Altshuler gave you the statistics, but I'm asking you to look into your hearts. I urge you to pass SB 555 so that we can save lives together. Thank you.
Good afternoon. Thank you, Mr. Chair and members of the committee. Since the 2020 legislative session, when Governor Sununu vetoed a similar bill, HB 687, bills like this, the one before us today, have been introduced in every legislative session, both in the House and in the Senate. And since the governor's veto was sustained, every attempt to pass a law that would allow family members or law enforcement to petition a court for an order to temporarily restrict access to firearms by individuals found to pose an immediate risk to themselves or to others has gone down to defeat. While supporters like myself have lacked the numbers to move a majority, each passing year seems to turn the names of more American cities and towns, from Buffalo to Uvalde to Lewiston to Providence, into tragic reminders of why we must pass this bill. But mass shooting cases, while shocking and horrific because of the sheer number of people killed and injured, are really only the tip of the iceberg. Last year alone, 38,722 people died in this country because they were on the wrong side of the barrel of a gun. A shocking 62% of those deaths were gun suicides. In the end, these unfortunate people had more to fear from themselves than from anyone else. It's a fact that no law can prevent every person who has a grudge from taking it out on innocent people. In the same way, no law can prevent every person who has a gun and also suffers from suicidal ideations from taking their own life. But it's also a fact that in 80% of these suicide cases, people telegraph their intentions to others. And when they do, the absence of a law like SB 555 can mean that lives are lost that could have been saved. Over the years, I've heard many claims by opponents of bills like this, and we heard some today. A big one is that bills like this go too far and would weaken the constitutional rights of law-abiding New Hampshire citizens. The fact is that 21 other states have established a legal process that, like the one outlined in this bill, would temporarily restrict access to firearms by people in crisis or by people who present an imminent risk to themselves or to others. It's also a fact that these laws have been repeatedly upheld in the courts as constitutional. In February, Maine is actually going to become the 22nd state to adopt a law like this. And Maine actually adopted its law after an earlier version of this law that didn't allow family members to petition the court was basically found, I think one of the things that became apparent after the Lewiston tragedy was that it wasn't quite as strong as it needed to be. So what Maine has done is they've actually, by referendum, have passed a law similar to the one that we're considering today that actually would allow family members to petition the court as well. Another claim is that a bill like this could lead to situations where law-abiding Granite Staters have their property seized with no notice and no opportunity to speak in their defense. The fact is, SB 555 has due process protections built in, with full hearings before judges, witnesses, and evidence taken from all parties. In a case where there is an imminent risk of harm, courts may temporarily remove firearms from a person in crisis prior to a hearing, but for no longer than 5 days. By that point, a hearing must be held and all parties have the right to appear. Multiple courts have ruled that bills like this meet due process standards by providing prompt, full evidentiary hearings shortly after the temporary ex parte order is issued. The U.S. Supreme Court has also long recognized exceptions for urgent public safety matters, such as in cases of domestic violence or child removal in an emergency. In cases like these, the court has repeatedly recognized, and I quote, that where a state must act quickly or where it would be impractical to provide pre-deprivation process, post-deprivation process satisfies the requirements of the due process clause. The bottom line is that this is a very good bill. If we pass it, it will save lives and reduce the risk of a city in our state becoming synonymous with the name of an unspeakable tragedy. I urge the committee to give it a strong ought to pass recommendation.
Okay. Hello, my name is Kathleen Slover. I'm from Portsmouth, representing myself. Please vote ought to pass on SB 555. I've submitted a link to an op-ed by Ann Jordan, the executive director of the Lewiston Commission, which was tasked to determine the facts leading up to the horrific night that left 18 people dead, 13 injured, and a community traumatized. After the investigation, Ann Jordan came out in strong support of Maine's red flag law, saying it empowers families with a tool. Often families know best. In November, Maine passed a red flag law with over 60% of the vote. And in 2023, a Granite State poll conducted by UNH found that 75% of Granite Staters approve of some type of protective order that prohibits a person who is deemed a danger to themselves or others from buying a gun. In 2014, the FBI published a report to identify the motive of an active shooter and to examine specific behaviors that may precede an attack. They found that, on average, an active shooter displayed 4 to 5 observable concerning behaviors, In response to observing these behaviors, most people talked directly to the would-be active shooter. Some did nothing, and less than half went to the police. With the 5-year average rate of gun deaths rising 22% in the United States and 48% in New Hampshire in the last 25 years, people need tools. And one tool is an extreme risk protection order, an ERPO. For example, in New Hampshire, most gun deaths are firearm suicides. A study published in 2024 found that ERPOs can be an effective and important suicide prevention tool. In my testimony, I provided a link to that very good study, and it can answer a lot of your questions that have been brought up today. ERPO provides due process fitting well within the constitutional due process framework. After the 2022 Bruin decision, new scrutiny arose around ERPOs, but with U.S. versus Rahimi, which reaffirmed the constitutionality of restricting firearm access and domestic violence protection orders after a notice and a hearing, which ERPO also has, ERPOs have passed the due process and Second Amendment test. Finally, most ERPOs are petitioned by law enforcement, even though they are civil orders. ERPOs are not mental health diagnoses. They are for people in crisis, in extreme risk of harm, which is why police are often called and why there's even an emergency ERPO in some laws. They temporarily remove access in order to provide vital time to get the help people need. I'll finish up with an excerpt from testimony that I believe was submitted online, and I highly hope that you recommend going online and reading that testimony. She's by a friend whose 20-year-old brother shot himself in the head. She says, before shooting himself, he was in crisis. He was on the verge of eviction, he was depressed, and he had a gun, a most dangerous combination. We knew he was suicidal. He wasn't my child, he was an adult. Where was I or my family to go? A visit to the police for an extreme risk protective order and have his gun taken away until the crisis passed. Thank you.
Senator Fenton, great to see you. You're going to introduce SB 463, I believe, an act relative to possession of firearms in safe school zones.
That
Go
is
ahead, sir.
me. All set?
Yes, sir.
Well, thank you, Mr. Chair and members of the committee. I know it's been a long day, and I want to thank you for the work you do in this committee. I know you've heard a lot of controversial bills today, and I appreciate the attentiveness of the committee and the dialogue you've all had today. For the record, I'm Senator Donovan Fenton. I represent District 10. I'm here to introduce Senate Bill 463. This legislation addresses the possession of firearms on school properties. I come before you wearing several hats: as a legislator, as a gun owner who values and exercises my Second Amendment rights, and most importantly, as a father of young children. Let me be clear at the outset. This bill does not restrict my rights as a gun owner. I own firearms. I respect responsible ownership. Nothing in this legislation prevents lawful ownership, lawful carry in appropriate places, or self-defense. What it does draw is a clear, common sense boundary around schools where children are present and where clarity matters more than anywhere else. This year alone, there have been at least 233 school shootings in kindergarten through 12 schools across the country, along with several more colleges and universities. Those are not abstract numbers. Those are classrooms, hallways, cafeterias, and campuses that look just like ours. Recently, my son, who's in first grade, had one of his first lockdown drills at his school. Like many parents, I had to try to explain to him what that meant. I had to explain that if there's someone with a gun at your school, you don't ask questions, you run, you hide, and you listen to your teacher. And then comes the part that makes no sense to a child, and frankly shouldn't make sense to any of us. I also have to explain that that person with a gun might be allowed to have it and to be there. That teachers are supposed to somehow distinguish between a lawful carrier and a deadly threat in a moment of panic. That's an impossible standard to put on our educators. Under current law, an adult can walk into a school with a firearm, and teachers and staff have no clear guidance. Do they initiate a lockdown? Do they ignore it and hope for the best? Do they assume everything is fine until it isn't? That ambiguity puts lives at risk. This bill removes that ambiguity. It allows potential threats to be identified immediately. We've seen how critical that clarity is. We've had the hospital shooting here in Concord where law enforcement was able to act quickly because the threat was immediately identifiable. Schools deserve that same clarity. 463 is simple and reasonable. If you're dropping off or picking up your child, keep your firearm secured in your vehicle. Law enforcement officers, active duty military are still permitted to be armed. No one's rights are erased. What changes is the expectation that schools are gun-free school zones where threats are unmistakable and response times are faster. I was headed into sixth grade when Columbine happened. Since then, generations of students, including my own children, have grown up practicing lockdowns, evacuations, active shooter drills, and I don't want fear to be a defining feature of their education, and I don't believe it has to be. There's no legitimate reason for an adult to bring their firearm into my son's first grade classroom. None whatsoever. Unless they are law enforcement. This bill also sends a message about who we are and what we value. When we prioritize safety in schools, we create environments where kids can learn, teachers can teach, and parents can breathe a little easier. Safety is not a political statement, it's a responsibility. And members of the committee, I'll close with this. I am a gun owner. I strongly value my Second Amendment rights. And I'm also a parent, and in this case, those two truths are not in conflict. So thank you very much. I'm happy to take any questions.
Seeing none, thank you.
Thank you.
For your testimony and bringing the bill. Mr. Simkin, last time today, if you're still here. Oh, you're still there.
Thank you, Mr. Chairman and members of the committee, for giving me an opportunity to testify. I am not a quitter. I stay the course. This bill, if enacted, will import into New Hampshire a Massachusetts law, specifically General Law, Chapter 269, Section 10, small letter J. This Massachusetts law criminalizes the bringing into a school or onto school property any firearm, even by one licensed by Massachusetts to carry concealed firearms. The only exemption from it for a rank and file person like me is to get a letter from the person in charge of the school authorizing me to carry on school premises. I actually have such a letter because where I attend services in Lexington, Mass, the place of worship also doubles as a school. In my prepared testimony, I replicate the relevant provision of Massachusetts law. It is lengthy. I will not read it out of respect for your time. But it should be obvious that anyone bent on mass murder at a school or elsewhere is not going to be deterred by this law. At very best, Senate Bill 463, if enacted, will allow a prosecutor to add to the list of charges against a mass murderer a minor charge. You brought a firearm onto school property. That benefit, and I put benefit in double quotes, is far outweighed by the harm to the law-abiding that Senate Bill 463, if enacted, will do. We just heard testimony that there's no reason for anyone to bring a firearm onto school property. Wrong. Where I vote in Nashua, the polling place is a school. Now, because I have a New Hampshire pistol and revolver license under federal law, I can enter upon that premises, that school, lawfully to vote. So, am I supposed to give up my civil right to vote in order to be armed, or give up my civil right to be armed in order to vote? I repeat myself deliberately. For many years, decades, New Hampshire has been one of the safest states in the Union. And in the data table that I presented to you, and I'll provide you with another copy, from 1985 to 2022, the incidence of violent crime in Massachusetts, which has thickets of nasty and repressive laws as to firearms, has been a multiple of the incidence of violent crime here in New Hampshire. In short, those who admire Massachusetts gun control should go there. They can enjoy the same climate as we have here in New Hampshire. They will be happier, and so will we who stay in New Hampshire. I respectfully suggest that this bill be voted inexpedient to legislate. It cannot do what its backers claim to do, and it will ensnare many law-abiding folks, unless, of course, the bill includes a provision that, akin to signs posted in Berlin during the Cold War, attention, you are now leaving the American sector. So around every school zone, signs will have to be posted. This is a school zone. If you are carrying, do not enter. There's no provision that I saw in this bill for that. And I think most towns and cities would object to the cost of posting such signs. So I conclude that this bill, well-intentioned, is futile and dangerous to the law-abiding. And with that, I will cheerfully take any questions.
Thank you, Mr. Simkin. I don't see any, so you have a great day. Thanks for coming in.
Thank you, and stay well.
Thank you. Kim Moran. Moran? Thanks for your patience and staying.
It's always, somebody said earlier, entertaining us. Pretty much what this is too sometimes. Before I even begin, I just want to, there were some things that were said that weren't actually true.
Just state your name for the record.
Oh, Kimberly Moran, women, representing the Women's Defense League. Sorry, I didn't hear what you said.
Thank you.
In the 90s, I believe it's 1993, the federal government passed the Gun-Free School Zone Act. So all schools are gun-free. All public schools are gun-free zones in the United States. No one can just openly walk in with a firearm. No one can walk in with a firearm unless it's concealed and they have a permission, a pistol revolver license in New Hampshire from their state. So that's not a thing where any random person can walk in with an openly carrying a firearm. This legislation affects all Granite State parents, but it significantly impacts single mothers who choose to protect themselves from abusive partners or stalkers for the act of simply dropping their child off to school. This bill wouldn't allow them to protect themselves. It especially affects those mothers who walk their children to school. They obviously don't have a car that they could leave it in if that was the case. I realize they've added a line in this legislation that we've seen many years over, asking permission from the school. But we don't ask permission to practice our fundamental human right to self-defense in New Hampshire. We got rid of that law several years ago, and guess what? We were labeled the safest state in New Hampshire in 2025, the safest state in the country in 2025, and we're consistently one of the safest states in the country. If someone chooses to get their pistol revolver license, that is their permission slip to carry concealed on school grounds granted by the federal government and laws that already exist. Like all gun control legislation, this bill has nothing to do with safety. In fact, mass shootings increased since the Gun-Free School Zone Act was passed in the 90s because criminals know no one in that school is going to stop them. This is everything to do with for infringing upon our Second Amendment rights and our ability to protect ourselves from danger.
Good day. Kathleen Slover.
Hello, my name is Kathleen Slover from Portsmouth. Representing myself, please vote ought to pass on SB 463. New Hampshire does not have a state law prohibiting firearms on school grounds. Only students are prohibited. So a parent can drop his firearm on the playground, lose the clip, have a child pick it up the next morning and get the clip back from the police station, no questions asked. Or a parent can bring a gun to the basketball game with no questions asked. On Wednesday, April 12, 2023, a man outside of Portsmouth High School posted a video of himself with a handgun and the text, "I'm going to shoot up the school." Law enforcement later recovered from his vehicle an AR-15 rifle, a shotgun, camouflage body armor, a handgun holster, a red dot sight, and numerous rounds of ammunition. The FBI special agent in charge said the danger posed by this man was very real. He not only threatened to commit a mass shooting at Portsmouth High School, but he had the means to do it. My son was in that school at that time. The man was charged with a felony and sentenced to 37 months in federal prison. Shockingly, when the man threatened PHS, he had legal possession of those firearms on school grounds. In 2022, New Hampshire passed a law which prohibits counties, towns, and school districts from enforcing or cooperating with any federal law that is inconsistent with any law of this state regarding the regulation of firearms. The lack of state law leaves school administrators and police departments in murky waters and is putting students, educators, school districts, and police departments at risk. If there is a federal law, I just don't know why we just don't put a state law in place as well. The argument that gun-free zones are targeted by active shooters is unfounded. In a research review conducted by RAND, the findings of the effects of gun-free zones, including campus carry laws, are inconclusive at best. Prohibiting firearms on school grounds passes a Second Amendment test, as stated in the Bruin decision, which stated that courts can use analogies to long-standing laws forbidding carrying of firearms in sensitive places such as schools and government buildings. A gun-free school zone is effective because it establishes norms by creating a general understanding of who should have guns and who should not. Is the parent at the basketball game an off-duty police officer or a disgruntled ex-spouse, or none of the above? If someone saw the man in front of PHS with his gun, was he a threat or just someone practicing his Second Amendment right? A gun-free school zone would make it clear that school districts and police departments can enforce gun-free schools. This makes people feel safe, especially in questionable situations, and eliminates confusion and chaos if a heated or dangerous situation arises. Thank you.
Thank you for your testimony. Megan Tuttle. She left, okay. Mr. Muse, you are backup representative.
Thank you, Mr. Chair and members of the committee. I don't have prepared remarks, but what I do have, I guess, sort of falls into more of the category of a comment. During the Brown University shooting in Providence last month, one of the things that struck me about some of the news coverage afterwards was the fact that some of the kids who actually went through that at Brown had also gone through the same thing in their high schools. So there was a student who was at Parkland High School during the Parkland shooting in 2018, who was also on the Brown University campus at the same time. We're actually getting people now who've become multi-generational victims of this. One of the things I would like to point out too is that keeping firearms off of school grounds isn't something we need to do because of who you are. It's something we need to do because of where you are. And that's something that the Supreme Court continues to recognize in decisions like Heller and Bruin. There are places like courtrooms and schools that are specifically mentioned that continue to be places where the court says exceptions are allowed. Given the danger from things like drop weapons, misfirings, arguments that unexpectedly flare up at inconvenient times, all of the different reasons why people may get angry with each other, may get mad at each other, may have a grudge or something like that. The last thing that I can imagine is why anyone would want to carry a firearm onto a school ground. And maybe this is just because of my particular point of view. But I have an extremely hard time sometimes wondering why in this place of all places we can't agree that we should restrict the carrying of firearms. I will never, I'll never understand it. I also remember David Welch, before I came in the House, there was a bill that was being argued, and we have another bill like that that's coming on allowing guns onto university campuses. And during his speech, one of the main reasons why David, who was a colleague on the Criminal Justice and Public Safety Committee, one of the reasons why he said he opposed the bill was because he had a grandchild that was going to UNH. And I think this is something that we all need to keep in mind. There are extremely good reasons for these protections. There were extremely good reasons why the federal government enacted this prohibition. And the fact that we don't enforce this prohibition in New Hampshire is problematic, and it's something that this bill would fix. So I urge you to pass it. Thank you.
Thank you very much. Sarah Tillotson? Oh, I'm sorry. Wait a sec. He has a question for Representative Mace.
Thank you, Mr. Chairman, and thank you for taking my question. As your former colleague on the Criminal Justice Public Safety Committee in the other chamber, just a question. Lines 8 and 9. There's 3 exceptions to when this law would apply. This one has to do with the person picking up and dropping off a student.
I'm sorry, could you speak? I have a little bit of hearing issue into the microphone.
That better?
That is better, yes.
So on page 1, 8 and 9 of the lines I'm referencing, where it's the exception where if someone's dropping or picking up someone from the school, in that scenario, they're allowed to have the firearm on the property, but they has to be unloaded and then be locked in a container or on a firearms rack. I'm just, in that scenario, regardless of where you are in this underlying policy, I look at that as someone who is now having to handle the firearm on school property, perhaps unnecessarily. Meaning, if I were to be carrying a firearm and I go to pick up a student from the school, I have to now unload lock it up, do all the stuff. I'm not gonna do all the driving. I'm just saying, like, now I'm handling the firearm in a vehicle on school property. Like, just that provision alone is what I'm talking about. How would you want that implemented, where a person has to do that? Or is that creating
I'm sorry, you're saying that position.
Does that create a greater risk of having the person having to handle the firearm on school property to now unload it and lock it up?
I think a person who has knowledge of that law who's actually concerned that somebody's going to be checking in their car, which I'm not quite sure anybody will be. But I think a person like that would also have the option of removing it before they go to school grounds. People load and unload their firearms all the time, right?
What I'm asking though is the appropriate place to be loading and unloading a firearm on school property when you go there? That's the point I'm making.
I don't think there's anything in the bill that says that it has to be done while they're on school property. It just simply says that it has to be unloaded.
Thank you.
Yep, thank you.
Thank you, Senator Osler.
Thank you, Mr. Chair. Thank you, Representative Muse. Thank you for your work on the Criminal Justice and Public Safety Committee. Are we allowed to bring firearms into New Hampshire courthouses?
We are not.
And why do we not do that?
My understanding of why we're not is that and I think we've actually seen this on occasion when firearms have been brought into courthouses. We need to protect the people who are in the courtroom. We need to protect the judges, the prosecutors, the defense attorneys, the defendants, the people in the gallery. I think over the years, I think we've all seen and read numerous cases, about numerous cases when somebody has managed to get a weapon by, which I think every time that happens, it just reinforces the need one more time that we need prohibitions like this in certain places. And I think the Supreme Court and the General Court of New Hampshire, when it actually wrote that law, it was a very, very wise thing to do. And I think we have an opportunity to do a very wise thing with this bill as well.
May I follow up?
Yes.
So using my colleague's example, if you know you're going to court, would it not make sense to not bring your firearm with you that day or to leave it locked up in your car because it's not allowed in the courthouse? To make those plans ahead of time, since you know you're going to court, kind of like you'd be going to drop off at school, that you would make accommodations before you got there. That's a you problem. That's a you responsibility, right?
I would agree.
Thank you.
Thank you.
Good afternoon. My name is Sarah Tollefson, and I'm here as a private resident from Goffstown to support Senate Bill 463. I'm co-founder of a group of parents called Goffstown Parents in Action, a nonpartisan group that formed after Uvalde to practice ways to prevent gun violence in our schools. I'm also married to a law enforcement officer, and we have safely secured firearms in our home. I share this because I'm not here representing one political side. I'm here for logic, reason, and protecting our most vulnerable. After Uvalde, our group brought together parents from across the political spectrum. We worked through our local democratic process and successfully advocated for additional safety measures, namely door barricading devices in all of our schools. Our town, Republicans, Democrats, Independents, all came together for our children. That's the spirit I'm asking you to embrace today. Here's why this bill makes sense. First, it addresses location-based risk, not lawful ownership. Schools are uniquely sensitive environments with high concentrations of children. Location-based restrictions are already widely accepted. You experience them when entering courthouses or government buildings. And many of us also choose to relinquish our right to arms when we attend an event like a concert or a hockey game. It's not radical, it's reasonable. Second, we already treat schools differently. We have controlled entry points, lockdown drills, and safety planning under RSA 193D. Allowing unrestricted firearm carry undermines these existing protocols. Third, this bill preserves local control. It's not a blanket prohibition. It includes reasonable exceptions and allows school boards to make decisions for their communities. This is very much the New Hampshire tradition. And finally, it protects children, which is all of our duty. My group in Goffstown is just regular people with little power to make change. You all have a lot. I'm asking you to set aside political differences and let logic, reason, and protection of the vulnerable guide you. The people you serve need to see that unity now more than ever. And if you'd like to discuss making Goffstown's safety model statewide, please reach out. Thank you. I'm available for questions.
Thank you.
Thank you.
Deborah Hobbs? From AFT, she's gone, okay. Seeing anyone else wish to testify in SB 463? Didn't I already get you at the beginning, Mr. Simpkin? Sure. If you'll be really, really quick. Go ahead, sir.
I simply want to answer factually a question that was just posed. May I do so?
Sure.
Thank you, sir. The question that was posed, I paraphrase, was, we can't bring firearms into courthouses. Why should we be able to bring them into schools? Here's the answer. It's factual. Courthouses have armed security. They have armed security because there are present in courthouses, at times, violent criminals. So courthouse security wants to be sure that they can protect the judges and the court staff. The only other place, correct me if I'm wrong, off limits to those carrying firearms in New Hampshire are prisons. Prisons have perimeter and interior security. I shouldn't have to state the obvious, but what was told to you was simply not correct, and I view myself, and I hope you view me, as a purveyor of sound facts. Thank you for leave to answer the question, and I hope the rest of your week is productive but boring, because boring is good.
Thank you very much.
You're welcome, sir.
And seeing no one else wish to testify, we will end the hearing on SB 463. Yeah, we're done for the day. I don't want to. Senate Judiciary is now adjourned.